Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are discussing about the frivolous public interest litigation petition for which the petitioner was ordered to pay 1 lakh as exemplary costs. Friends, you all know that the concept of public interest litigation emerged maybe during the year 1978 or 79 when late Sri P.N. Bhagavati was the Chief Justice of India and he was proactive, pro-public. You all know there is no specific definition for the public interest litigation, but we all know that it is an exception to the principle of locus standi. Locus standi, that means the person who suffered, the person who was injured, the person who has borne the loss, then he can file a case. Maybe under Article 32, Constitution of India. So whenever we discuss public interest litigation, we tell you only after 32 of the Constitutional article is over. It is also peculiar. So whenever your fundamental right is violated, you have got another fundamental right under 32 to get the redressal. Okay. This is a different part. Anyway, coming to this public interest litigation, no doubt, even though there is no definition from 1979 onwards, public interest litigation is being accepted and the Supreme Court is also kind enough to take up the petitions. But public interest, what is public interest? No doubt, you may not have personal interest. If the public in general are suffering, if the public in general they have got a grievance, then it can be brought to the notice of the Honorable Court. But in the name of public interest litigations, so many publicity interest litigations are being cropped up. Why? Because when once you file a public interest litigation, once it comes up to the court for hearing, normally your attention will, public will draw your attention towards you. Evarina kottaga isaru eventi public ani chaala mandi చూస్తుంటారు దాని కోసం అలాంటిదే జరిగింది. Here very recently, I think on 5th day before yesterday, a public interest litigation filed by the petitioner Upendranath Dalai, it has come up. Of course, he is a devotee of Satsang, an organization founded by late Sri Ankul Chandra. Actually, this Ankul Chandra is no more, but he is a very good religious leader. Actually, he is from Bangladesh, Pabna district of Bangladesh, but of course he migrated to Chhattisgarh or some other state, and he is there. But his devotees, the religious fervor is there. Now, one of the devotees by name this Upendranath Dalai, he has filed a public interest litigation that the public or the citizens should treat late Sri Ankul Chandra as Paramatma. This is the public interest litigation. We have to declare him, the government should declare, or the citizens should declare him as Paramatma. This petition was filed under Article 32 of the Constitution of India to declare Sri Ankul Chandra as Paramatma. The matter came up before two judges bench, Justice M.R. Shah and also C.T. Ravi Kumar. And when the matter came for hearing, the petitioner started reading the entire public interest litigation petition. Then M.R. Shah said, "Brother, we are not here to listen to your lecture. Please tell us the brief facts." Then he started telling that Ankul Chandra was a great man, he was a religious leader, he should be treated as Paramatma. Then M.R. Shah said, "Do you know, brother, do you know, India is a secular country. There is no religion to the country. Of course, Article 26 to 25 to 28, they declare that you can profess, you can propagate, you can maintain any type of religion you like. That's all. India is a secular country. It will not declare so-and-so as Paramatma also. Do you know this? But once again he started saying, Ankul Chandra was a great man, he was a religious leader, he is equal to Paramatma, Supreme God. Then they said, it is not correct. We are not here to listen to your lecture. We are a secular country. No doubt, brother, if you have got respect, you have got religious fervor or religious feelings towards him, you can definitely call him, or your friends can call him as Paramatma. We don't have any of them. But you cannot insist that citizens of India should accept him as the supreme post or Paramatma. This is not correct. In India, everybody has got a right to choose his own God. So ultimately, it is nothing but wasting of the time of the Honorable Court, and also it is not public interest litigation, it is only publicity interest litigation. Therefore, the petitioner is fined or is directed to pay exemplary costs of 1 lakh, which has to be paid to the Supreme Court registry within 4 weeks. So, what I want to tell you is, whenever you want to file a public interest litigation, you must be doubly cautious. Lastly, Justice M.R. Shah said that with this, if anybody wants to file a public interest, he has to think 4 times before filing this. Yes, certainly. But anyway, we should not waste the value of the Honorable Court. Time is very, very precious for them. Already they were overburdened with the pendings of cases. And before parting with this video, I wanted to impress upon you that if you want to file a public interest litigation, be sure that it reflects the general public. Be sure that it is for the general public. It is for the welfare of the general public. Then you can file. Otherwise, such a type of petitions just we discussed, they will be frivolous, waste, and ultimately you have to pay the so-called exemplary cost. With this, I am stopping. Thank you very much.